Hello friends, how are you? Today in the present lecture series, I will discuss the basic concept of Section 7A of the Prevention of Corruption Act, with the aid of a recent citation of Honorable Karnataka High Court wherein the accused has been acquitted. This video is in English and the Hindi version of this video is also recorded for the North Indians and for those who are not able to understand the English, and also for those who are not well conversant in the English. Friends, if a person is implicated or going to be implicated under Prevention of Corruption Act or Prevention of Money Laundering Act or Benaami Transection Act, it is very much difficult for him to get rid from the problem because even the court consider him the culprit. But the basic rule of jurisprudence is that every person shall be deemed to be innocent unless proven guilty. But the type of evidence, the nature of allegation, whenever imputed on us, everyone consider us as a culprit. Remember one thing, you are not a culprit and never consider yourself as a culprit. Whatever you have done is a mere allegation. Still, they are required to be proved by the prosecution in the court of law. The burden is on the prosecution by the virtue of Section 101 of the Indian Evidence Act. Until and unless foundation facts are proved, you cannot be deemed to be guilty, and apart from that, you are not supposed to rebut the presumption unless they prove the foundation fact. Once the foundation fact is proved, the court may draw the presumption, but to rebut the presumption, it is not necessary that you should come in the witness box as per Section 315 of CRPC, and apart from that, it is also not expected from you that you should depose as per the mercy of the prosecution, as per the mercy of your counsel. The law requires that you are required to stand your defense as per the protocol of the preponderance of the probability. So these are the basic concepts. We will discuss the same in detail in this video. Please keep a copy and pen with you or a pencil with you, and whatever I am going to narrate, please note down the same, so that if you are having the same trouble in near future or if you are having the set trouble right now, this video might be a nectar for you to get resolve your problem, and apart from that, you could easily get solution in the same. Okay, so now we are going to start the presentation. Let's move on the screen. Friends, the judgment is passed by Honorable Karnataka High Court. Citation is Mahesh PS versus State of Karnataka, and it is pronounced on 24th of May 2023. Now we get the credential of the case. First, the name or title. Number 2, the code by which it is pronounced, and number 3, the date of judgment. Okay, now we are moving ahead. In this case, the petition for quashing has been moved. That is very much important. Quashing means the extraordinary power is to be exercised by the High Court to quash the proceedings which are totally abuse of process of law. And apart from that, the offence alleged against the accused in the FIR is Section 7A of the Prevention of Corruption Act, and the current file regarding the same is pending in additional city, civil and sessions judge and special judge PC at Bengaluru at that time. The petition was heard on 21st of April 2023, and the court has made the following order. The criminal petition is filed by the petitioner accused under Section 482 of CRPC. You got the point now? For questioning of the proceeding of the concerned crime registered with the ACB, now pending with Lokayuk. As you know that in Karnataka zone, ACB has been dissolved and every proceeding is pending with the Lokayuk. It is regarding the offence punishable under Section 7A of the Prevention of Corruption Act, and the matter is pending at that time before the additional city, civil and session judge and special court for the PC at Bengaluru. Friends, the case of prosecution is that the complaint of Mr. Azam was filed on 20th of May 2022. That is important. And ACB police registered the case. It is alleged that the complainant is running a mutton shop and he is having a land of a particular measurement situated at a particular place, and the same was purchased by him in the year of 2014. He got transferred the same in the revenue record in his own name, that is called the proceedings of mutation. The complainant wanted to convert the said land into residential land, and there was a case pending before the Assistant Commissioner of Revenue concerning the same, and the same was rejected on 24th of December 2020. Hence, the complainant filed a revision before the Deputy Commissioner Bengaluru, and after inquiry, the case was reserved for order by the Deputy Commissioner, and the order is awaited. Subsequently, complainant approached the Office of Deputy Commissioner on 18th of May 2022, and the said Deputy Commissioner returning back. At the time, the complainant said to be met, the petitioner accused number 1 and the Deputy Commissioner went away. It was further alleged that When the de facto complainant went to the chamber of petitioner and sat in front of his table, at that time the petitioner said to be asked a staff to bring the case file of the complainant and asked as to what was the arrangement that he has done in the case and what was the bribe amount. The petitioner said to be wrote on a piece of paper as 15. It is meant 15 lakhs. The informant complainant expressed his inability. Then the petitioner wrote 8 on the piece of paper, but the informant complainant offered to pay only 3 lakh rupees. So the petitioner wrote 5 on the paper. Then the complainant took the piece of paper with the video, audio recording and lodged the complaint to the ACB. And finally, ACB registered FIR and set up the trap. And finally, informant took the money, and while handing over the same to the accused number 2, when he was caught red-handed, a seizure panchnama was prepared. And finally, the police arrested the petitioner and shown him as accused number 1, and police took up the investigation, which is under progress, and it is challenged by the concerned accused number 1, means petitioner, before the Honorable Court. So by these facts, we are totally clear that the concerned complainant has a land. Number 2, it was mutated in his name. Number 2, for the purpose of residential, he inter alia applied for the residential conversion use, but the same was rejected, and ultimately he has submitted the appropriate petition before the concerned deputy commissioner, and deputy commissioner and the concerned person had demanded the alleged bribe, and while doing the alleged transaction, one of the accused, named as accused number 2, caught red-handed. Now everything is clear to you, na? Okay, na? I am going to proceed further. Now the petitioner contend that as per the complaint, a demand was made in the month of November 2021. This fact is on the record. And the FIR was registered on 20th of May 2022, after a long gap between demand and lodging of complaint. And as per proviso to Section 8 of the PC Act, the complaint shall be filed within the 7 days. Absolutely, there is no demand and acceptance by the petitioner. Amount even not seized from him, amount is seized from accused number 2. There is no telephonic conversation between the petitioner and the complainant regarding demand of bribe, and apart from that, no work of the concerned complainant was pending with the petitioner. The revision case was pending for order before the deputy commissioner, who is accused number 3. Revision case was also pending for order before the deputy commissioner. He contended that the discussion of the complainant with the petitioner set to be held on 18th of May 2022 in the chamber of the petitioner, but the telephonic conversation revealed that the petitioner told that they are in the month of January up to February, March, and it can be done. It is further contended that if all the demand was made on 18th May 2022, the question of conversation could not be said to be occurred in the month of January, February, or March. So the contention of the complainant regarding demand, which was alleged to be made on 18th of May, appears to be false. It must be either in December or in January or in February or in March. So the contention of the complainant that demand was made on 18th of May 2022 is apparently false, and therefore the case of complainant is false. He submitted that the acceptance of bribe was from the accused number 2, who is a private person, and he has nothing to do with the present petitioner accused number 1. The genesis of complaint itself is false. As I submitted earlier, the police, in spite of lapse of almost a year, not able to file charge sheet against the petitioner, since they are not able to get the proper evidence. So it is argued, as per judgment of Honorable Supreme Court passed in Neeraj Datta versus State of NCT, judgment is pronounced for the 2 times. First, 15th of December, the first part of judgment, and second, the final part is on 17th of March. It is clarified that there is no demand and acceptance and pendency of work which is sine qua non if the foundational facts are not on the record. In that scenario, conducting investigation and further proceeding would be abuse of process of law. On the other hand, the proceedings are opposed by the concerned Lokayukt can be duly proved against petitioner accused number 1. And the telephonic conversation also occurred between accused number 1 and the complainant. It is contended that the conversation, likely January, February, March, are code words used by the accused person for demanding money. So work is pending with deputy commissioner, it is admitted, but the file is seized from the custody of petitioner. So material is available on the record. At the prima facie level, the court has to see the material, not to evaluate the evidence. So under section 482 of CRPC, the court could not decide the controversy. The court has to see the uncontroverted fact and all the facts available on the record indicating the guilt and implication of the concerned accused in the present crime. Learned counsel for the complainant also opposed the concerned petitioner by submitting that there is evidence on the record in the form of audio recording, video recording, and the clip clearly reveals that the demand was made. And apart from that, the conversation also took place. So in that scenario, when the evidence exists on the record, it is not appropriate to reject the contention of the concerned complainant and the state, rather than it is a fit case to dismiss the petition. So these are the basic contention on the part of the concerned. Complainant respondent number 2. The court has considered the rival contention of the party, even peruse the records, which is quite necessary in these cases. The record revealed that the complainant first informant is having a case before Deputy Commissioner. This fact is uncontroverted. And admittedly, the work is pending with Deputy Commissioner. The petitioner accused number 1 is a rank of Tehsildar, working in the office of Deputy Commissioner. The complainant set to approach this petitioner on 30th of March 2022, wherein complainant was informed that the case was reserved for order by the Deputy Commissioner. It is contended by the complainant that the order should be prepared on 18th of March 2022. The complainant has categorically stated that he met with the accused petitioner on 18th of May 2022, wherein he has made the demand of 15 lakh, reduced the same to 5 lakh after getting scaling or bargaining. The petition is said to be mentioned the bribe amount in the chit means a piece of paper. The learned senior counsel for the petitioner contend that the pre-trial Panchnama and transcription of telephonic conversation together different, and there is no demand and acceptance by the petitioner. So these are the important contentions, because whenever you are going to read your case, just read the complaint and read the alleged conversation. You will definitely find the difference in the same, because in the complainant is damn sure that you are demanding the money and you are in the anxiety to accept the same. But in the conversation, usually it appears, hello, namaskar, how are you, why you are here, just have a seat, now tell your problem. And after that there is some exchange of words, and this exchange of words inter alia inferred by the ACB or by the Lokayog or by the concerned vigilance as a demand of bribe. So the story set up in the concerned complaint should be matched with the transcription. If it is not going to be matched, definitely the position will be favorable concerning the accused. You got the point now? Now it is easier now. So at this stage, everything is clear to us. So now we are emphasizing on section 8, because the hit of the defense is that the date is totally fictitious, because it is totally mentioned so that the case could be inter alia brought within the provision of section 8 of the PC Act. On perusal of pre-trial Panchnama, it is mentioned that now we are in January. It can be done up to February or March. The learned senior counsel further contended that if the conversation was in 18th of May, the question of mentioning in January, March or February cannot be arisen. And apart from that, it is an indication of false implication of the accused in the present case. Even the perusal of pre-trial Panchnama clearly reveals that the conversation between the petitioner accused number 1 and the complainant reads as under. There is something in the Kannada language in which it is mentioned that the work will be done in the month of January or February or March. So the basic conversation, if taken place on 18th of May 2022, it could not be said that there is any demand on conversation in the month of January, February or March. So, and everything is showing that the petitioner never demanded the alleged bribe from the complainant, and everything is false, and he is falsely implicated in the present crime. So if the demand is made indirectly, it must be in January or February or March, but it is next to impossible that it is made in the month of May, referring the month January, February or March, and the same is indicative that it is in the violation of section 8 of the Prevention of Corruption Act, because as per section 8 of the Prevention of Corruption Act, the demand should be reported within the period of 7 days to the authority. If it is not, it is totally fatal for the prosecution. And apart from that, the trap was conducted and the amount was paid to the accused number 2, who is a private person. The same is seized from accused number 2. It reveals that there is no demand and acceptance of bribe from the accused number 1. And apart from that, work is not pending. It is pending with Deputy Commissioner. There is no consent recovery from accused number 1. In fact, the work is pending with Deputy Commissioner. And apart from that, the matter was heard on 15th of Feb, and subsequently it was adjourned, and finally dates were given, and final date given was 23rd of June 2022, and it is after the trap of the accused number 2. The learned counsel for the Lokayukt relied on the judgment of Honorable Supreme Court, wherein it is observed that at the stage of discharge, the court cannot enter into the evidentiary value and material adduced by the prosecution. He also relied on judgment of Honorable Supreme Court passed in the case of Neeraj Datta. So he submitted that it is not necessary to have the primary evidence. Even by circumstantial evidence, we could connect the accused with the crime if not reputed. So the primary key is that the court has to see whether the ingredient of section 7 of the PC Act is available or not. The court has seen the entire scenario. The court is of view that the petitioner accused number 1 neither demanded nor accepted any bribe from the complainant, and apart from that, no work is pending with him, and apart from that, there is no document to show that the petitioner has demanded bribe directly from the complainant, and alleged bribe amount has been seized from accused number 2, who is a private person and unconnected with accused number 1. and even otherwise the demand must be in January or February or March, but it is not possible that the reference is of January, February, March in the alleged conversation of 18 May 2022. And apart from that, the complainant filed a delayed complaint, and as per the protocol it should be filed within 7 days from the demand. And apart from that, the concerned defense has relied on the judgment of Honorable Supreme Court passed in the case of Kapil Agarwal versus Sanjay Sharma, wherein retail principle has been defined to exercise the power of section 482 of CRPC. And in the present case, the court applied the said citation, and the court observed that the entire proceedings are abuse of process of law. And in addition to this, the judgment of Vijay Kumar versus State of Tamil Nadu, that is an also recent judgment, has been relied upon. In this case, it is settled that the demand of immediate gratification is sine qua non. If it is not proved, then mere recovery of money could not connect the accused with the crime. The judgment of CM Sharma versus State of Andhra Pradesh, CM Girish Babu versus CBI has also been referred. In the present case, the complainant did not support the prosecution as far as demand by the accused is concerned. The prosecution has not examined any witness at the time who could allegedly seen the transfer of money to the accused by the complainant to prove that the same was in pursuant to demand made by the accused petitioner. The complainant himself had disowned that what he has stated in the complaint before the concerned authority, and apart from that, there is no other evidence to connect the accused with the alleged crime. So if the ingredients are not satisfied in that scenario, it could not be said that the accused is directly involved in the present crime. Therefore, the court inclined to hold that the concerned trial court as well as High Court was not correct in holding that the demand, and therefore it could be said that the learned trial court was not correct to hold that the demand alleged to be made by the accused stand proof. So the material available on the record is a recovery of money, but it is not from the accused number 1, it is from the accused number 2, and even there is no connection between the accused number 1 and accused number 2. If the basic connections are totally absent, so we could not apply section 7 and section 13(1)(d) of the Prevention of Corruption Act. So as far as the present case is concerned, section 20 of the Prevention of Corruption Act is also discussed. The court submitted that the presumptions could be drawn if ingredient of section 7 is satisfied, it is not for section 13. So basically the onus is on the prosecution to stand the case and to prove the case on the foundational facts. If it is not proved, even the connecting evidence is not on the record, and it is based on hypothesis view, in that scenario prosecution cannot be allowed to be continued. So the concerned court, by looking to the fact and circumstances, hold that the concerned police is conducting the investigation, and during the course of investigation there is no material collected against the petitioner accused number 1 to connect him with the alleged crime. Except a piece of paper, there is no evidence produced by the prosecution, and the same could not be a connecting evidence against the petitioner for demand of bribe, and even the same could not connect the accused with the present crime. So the prosecution has to prove the case by direct evidence, if it is not by circumstantial evidence, but there is nothing incriminating on the record. So continuing the proceeding against the accused petitioner number 1 would be abuse of process of law. So court, looking to the fact and circumstances, has quashed the proceeding up to the extent of petitioner accused number 1. Friends, by this judgment we are quite clear that the following are the shortcomings of the ACB case in that particular case. Number 1, there was a delayed report. Number 2, the conversation is not going to be matched with the alleged story that has been narrated on the record. Number 3, if there is a violation of the basic ingredients of section 7 or 13(1)(d) of the Prevention of Corruption Act by the concerned accused petition number 1, it is to be shown by the concerned prosecution by submitting the evidence. There is no evidence on the record. Even the complainant disowns from the concerned story of the prosecution, and apart from that, there is a piece of paper. The same could not be a ground itself to connect the accused with the alleged crime. And number 4 is that the connecting evidence should be recorded. There is nothing on the record that accused number 1 is connected with accused number 2 or accused number 3. In the absence of connecting evidence, pendency over motive, demand, acceptance, the accused could not be prosecuted under section 7 and 13(1)(d) of the Prevention of Corruption Act. So in that case, the proceeding has been quashed. So it is a very good judgment. If you are having the same trouble, same case, this citation would be quite helpful to you. Use it in the list of chronology of the citations and vehemently argue on the same, so that you could get a success before the concerned court. Best of luck for your future ahead. And apart from that, request you all to read out the case, make the proper notes, make the proper brief, make the proper research, and use the recent citation to support your contention. Usually I internally observe that your counsel never intend to file the recent cases. They say that we have to face a trial. Why to face a trial in a false case if there is nothing incriminating, nothing connecting against us? So my submission is that make a proper draft, make a proper submissions, and fight your case, and definitely you will win. So friends, see you in the next video. Till then, Jai Hind, Jai Bharat.